Good morning. The next case to come before the court is State of Ohio v. Joel A. Helms. Each party will have up to 15 minutes for their arguments. The appellant may reserve up to 5 minutes for rebuttal. And if you do plan to reserve time, Mr. Helms, please let me know as I'll be keeping track of the time. The arguments are being recorded, so please keep your voices up and remain behind the podium. You should not use the names of children or minors or victims during your argument, should that be relevant here. The judges have read your briefs and are ready to proceed when you are. Mr. Helms, would you like to reserve time for rebuttal?
Yes, I'll reserve 5 minutes.
Very well, then you may start when you're ready.
We have a case where on first exposure, it looks like there was a simple traffic accident and crime. But in reality, when we actually look at what the law says, is that you have to be, it's only a crime if it's hazardous when you're intending or starting to turn. When you're actually in the turn, it doesn't matter. Because the language is very specific, the intention of the turn. In this particular case, there's no question. I was totally stopped in the other side of the lane, across the lane. My vehicle was at a cross angle, totally blocking the other lane. And the other vehicle came up. The other driver actually didn't see anything. She doesn't know what happened, but she does know that I hit her. In reality, when we look at the video, we see that the only thing she hit was a sign. If you ever seen a traffic sign, they're on a post and they've got little knuckles every 8 to 10 inches to anchor things to and whatnot so they don't slide down the sign. And that's what's on her vehicle. You actually see the scratches of these knuckles on the vehicle at the right spacing, and you see the sign that's knocked over only 10 feet away from her vehicle when she comes to a stop. So the only statement of any witness is one of hers that I hit her, but there's no evidence where I hit her or if I hit her. And I think the evidence also shows that, I can go through, totally went through, in 15 minutes I could go through the whole trial and the whole transcripts, but there's no reason to repeat everything. I think it was very brief in my brief, delineating everything, that when she actually made her first turn, so she admits she doesn't know what happened, but her reaction as a driver, do we always remember? I know, I can drive someplace and do I remember how I got there sometimes? It's just such a rote that you do it. You don't always remember incidences unless something out of the ordinary happens. In this particular case, all she knows is she made a turn to avoid somebody, and then she doesn't know what happened after that. But the evidence is very, very clear that she did have, from the skid marks, she had ample time to stop. When she did turn, she made one turn in her skid marks. Had I been moving, had I been an object in front of her, subconsciously, whether she remembered or not, as a driver, I don't know if you guys are drivers or not, but subconsciously you react to things that you don't consciously know because you've been driving for so long. She made a 5-degree turn in the road to avoid me. And the next 140-some feet, she never deviated. Had I been moving, that skid mark would have deviated slightly. And so that's evidence that I was stopped. I was not in the act of moving at the time. The other incident also is when her skid marks passed my car. Had I hit her, the momentum of my car hitting her, that skid mark would have had a small bump in it. Little asymmetrical bump of where I hit her. No asymmetrical bump in her skid mark. And then, as you look at the officer's video, I mean, even though the officer didn't see anything, his video showed quite a bit. His video documented the skid marks. And at the very end, his video documents something that was very peculiar. I had an orange juice, half-gallon orange juice, on my front windshield. Because I was just going from one house to another house, 2 houses away. I thought my speed probably ever reached over 5 or 6 miles an hour, and going from my house to my sister's house. And if my vehicle would have hit, it's how when you carry water, how do you not slosh that water? Had my vehicle hit anything, that juice container would have flew off my windshield. So there's just no evidence that I hit her, that actually I violated the law, that there was a hazard. I showed basically on the map your evidence. You have 740-foot eyesight there. Once you come over a hill and a curve, that she could have seen my vehicle. Obviously, she only saw it in the last 1/3 of that distance. And you have to remember, it does take a certain amount of time for response time before you hit your brakes. So you see something, you evaluate it. Well, all we have is that response time, whatever it was, whatever her age was, whether she was a 16-year-old driver, which is the highest response times around, or a 70-year-old driver like me, that once that response time is over, most of the other times are totally mechanical. So what we see here are the pure mechanical times of the skid marks. Nothing to do with age or anything else. And those skid marks say she had ample time, I was no hazard, I was not near that intersection. So I think by the purpose of the law is that once I started that turn, there was no hazard. And I think it's very good. Even when you have a hazard right at an intersection, you start to make a turn, and a pedestrian walks in front of you, you stop. Now, does that make all of a sudden that you're guilty if somebody now comes up, 2 seconds later and gets you because you're waiting on that pedestrian to move? The way the law's written, you're not guilty. And it just, to me, it's just absurd. Okay, so we have, and then the second issue is that she came up with so many interpretations of what didn't happen or did happen that the judge comes up with his own conclusion. It doesn't even match anything, but he comes up with a conclusion, about the only conclusion he could come up with that would make me guilty. That she didn't move out of her lane, that she was doing everything proper, which the skid marks, the only evidence that I think that we can actually trust here, we can bet on. And obviously, was I a witness? No, I didn't see the accident either. I was looking up in the sky for smoke. So my only witness is the police officers, and actually going out there and measuring, which the police officer would have done probably. But so the police officer video is our best evidence. My only evidence is that I was stopped. But 5 seconds later, when the accident happened, I don't know what happened because I wasn't watching. Even though I was right there, I wasn't watching. And she basically said she doesn't know what happened either. So I don't understand how this became a crime. So thank you.
Thank you very much, Mr. Helms. You will have your full 5 minutes for rebuttal when the time comes.
Thank you. May it please the court, with respect to Mr. Helms' arguments that there was no immediate hazard when he struck the driver of the other vehicle, you heard him this morning indicating to the court that she could have stopped. She could have avoided him. What he's failing to indicate is the statute doesn't require her, to make any efforts to avoid that collision. She was properly driving down her lane of travel. The testimony indicates she did never leave her lane of travel, in that while she was maintaining her lane of travel, Mr. Helms turned into her driver's side door. There was testimony at the trial court with respect to the driver of the other vehicle, as well as the officer, who indicated that the damage to the vehicle was consistent with Ms. Smith's statements. The fact that he's hanging on, there was no immediate hazard. His turning into a lane of travel, striking another vehicle who had no duty to yield to him, is an immediate hazard.
Oh, counsel, he's charged with, the making a left-hand turn, with an immediate hazard as opposed to failure to yield.
Yeah, so the statute says the operator of a vehicle, streetcar, trackless trolley intending to turn left within an intersection or into an alley, private road, or driveway shall yield the right of way to any vehicle, streetcar, or trackless trolley approaching from the opposite direction, which is the exact situation in this case. He's turning this way, she's coming this way. She is coming down the lane of travel and he has to turn across to make his turn, making that left-hand turn. He has the duty to yield to her as him crossing her roadway.
I understand that, but there is the element of turning in front of an immediate hazard, as opposed to a failure to yield where we're at a stoplight and you're traveling on your road of travel and I failed to yield to you and you at the right of way. You see the.
I understand what you're saying. So potentially you're asking, would there have been another statute that may have been more?
Well, no, I think it was just a response to if he hits the side of her car, he's automatically guilty of the statute. But I think his argument is there's an extra element in there.
The immediate hazard element as well.
Yes.
Yes. So I get, what the state would respond to that, Your Honor, is that when he makes that left-hand turn, he's under the duty to ensure that he can do so safely without a hazard. And the state presented evidence and would argue today that when he makes that turn and strikes a vehicle in her lane with no duty, other than to travel within her lane, with no testimony she was outside her lane, when he makes that turn and strikes her, there is an immediate hazard because there was someone occupying a lane that she was entitled to be occupying that he had a duty to ensure wasn't there prior to crossing that lane of travel. With respect to his statements in his brief and here today with respect to the skid marks and the markings, there was no expert testimony presented at trial. I don't believe that Mr. Helms presented himself as an expert in order to present testimony with respect to the skid marks and what those skid marks meant. So I don't believe that is an appropriate argument that he should be making here today. And the state would, just again indicate that statute requires someone who's making a left-hand turn to ensure that they can do so safely without impacting another vehicle who's rightfully within their lane of travel. And the testimony at the trial court did present sufficient evidence that he failed to do that when making that left-hand turn, he struck another vehicle. And unless there's any other questions, the state would.
Just remind me, what was the evidence? How, in what form was that evidence?
Yes.
The state presented?
So the state presented testimony from Ms. Smith, who was the operator of that vehicle, who testified she was traveling down the road within her lane of travel, and that when doing so, she was struck. As well as the testimony from the law enforcement officer who indicated that her recitation of what happened on scene was supported by the point of impact of the vehicle. So it's the point of impact as well as the testimony of the other driver. And just a little bit ago, you heard Mr. Helms indicated that he was looking up into the sky. And so if he's looking up into the sky, he's not even assuring that he can safely make that turn. He indicated just shortly ago, and I believe testified at trial too, that he was looking at the sky looking for smoke, and that's why he was driving down there. So he was focused otherwise, not on the road, through his own testimony. And so the testimony was presented that she was driving, was struck in the side, driver's side, which would be consistent, was being turned into, and then that officer testified that that was also, the point of impact was consistent with her statement, and not consistent with what Mr. Helms had indicated had happened.
Thank you.
Thank you.
Turn backwards first. I was driving down there to do work, and only on turning, I find the transcript, I can't say exactly where, but on turning that I discovered the smoke. So The smoke wasn't even seen before I started to make the turn where she wasn't even around. And again, the constant that I struck her, there's no evidence. The video is very clear. The only marks on her side of her car, the whole side of her car, is these knuckle marks from the signpost, 3 sets of them, down the side of her car of the signpost she hit. There's no evidence that my vehicle, the only thing damaged on my vehicle was my headlight. And I assume the signpost hit that. But if my car would have hit her, my bumper is in front of my headlight. There's no bumper damage. There's multiple places in the video where the officer walks by her car, and you can see the signpost sitting on the ground, right, 5 to 8 feet away from the car, on the ground, that she carried with her as she stopped. So there's no striking her. It's just, the evidence doesn't show it. The fact that she says it once, but then contradicts herself 5 other times, that testimony, I'm sorry, should I have drummed it out of her or something? To me, it was embarrassing. To me, I felt embarrassed to ask her any further questions after I heard 6 different versions. I didn't want to embarrass the witness. She was under pressure. I could tell it. How many times did somebody have to change their story or basically actually be truthful about what they saw or what they felt happened? She has a memory. We all have memories of things that happen, or we try to, okay, well, this happened. Now, how did that happen? We try to figure out. And that's exactly the mode that she was in. So the striking her just didn't happen. You mentioned it, should I have yielded? Was there another? I actually was looking. I was hoping the prosecutor would come up with something different to charge me with, and would I accept an alternate charge? But in reality, did I have a responsibility to yield? I actually, because that's our property, our family's property, I could have, for any logical reason, blocked that road for up to 5 minutes, and I did not have to, move my vehicle if I was doing construction or something. I could block the state highway for that long if it was on my property, the way the deeds go, whatever. But when I started to turn, she wasn't there. There's just no evidence. My statements were in evidence. Her statements were of dubious quality. In reality, of so dubious quality that saying that she doesn't know what happened and was she really a responsible driver at the time, or was she worrying about her child or something like that, or talking to her kid. Who knows what took place? But it obviously, and I'm sorry, as for an expert witness, I've been driving a long time. I know what skid marks are. And when the skid marks show, I just can't stop. And my skid marks, both marks, go off the road, totally off the road, and then you claim, she's trying to claim that what the judge says is, oh, she never left her lane. She never was in her lane when she passed me. She was totally off the road. You can see, even in the gravel, the other tire, the skid marks on the other tire. There's no evidence that she was in her lane. Actually, had she stayed in her lane, she would have been able to stop. So, I think that's it.
Thank you very much. Thank you both for your presentations. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail you each the decision on the day that it's released, and the opinions will also be posted on the Ohio Supreme Court website. Thank you again.
Thank you.
Until Tuesday, June 6th, when we will meet in Suffolk County.